there is this one common mistake which most people, most clients do commit, is they approach the court after a stipulated period of time. Like if the offense is committed right now, they file a complaint, they go to the court after 4 or 5 years because they feel that there is no limitation period in the criminal law. But let me tell you that Limitation Act, limitation law has a great impact in the criminal law also. There is always the limitation period of filing a complaint, of taking the cognizance of the offense by the judicial magistrate. If you file a complaint after 4 or 5 years of committing the offense, the judge has the absolute power to ask you for the reason of delay. If the reason is not justified, then he will outrightly reject your complaint because you have approached the court very late after the limitation period has been expired. So you have to be very cautious in filing the complaint, in approaching the court. No matter you have filed the complaint in the police station, you can take a plea that I have filed the complaint in the police station on such and such date, but that will not be considered because you have approached the court after 3 or 5 years. So there are provisions in CRPC. I would like to read that aloud. That is section 468 of CRPC, which provides that the period of limitation shall be 6 months in the offences which are punishable with fine only, and the limitation period is 1 year if the offence is punishable with imprisonment for term not exceeding 1 year. If the imprisonment in the offence is not beyond the period of 1 year, then the power of cognizance by the court can be taken within a period of 1 year, which means you have to approach the court within a period of a year, otherwise the court will not take cognizance of the offence. And the third point is, if the offence is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years, in those cases the period of filing the complaint, the period of taking the cognizance by the court is 3 years. So always remember that CRPC has the limitation law also. You have to file your criminal complaint within the prescribed period. However, there are some exceptions to this rule. There are provisions like 470, 471 in which it is clearly stated by the legislature that you can justify your reason of delay in filing the complaint, in delay in approaching the court, but that should be a reasonable justification. If judge finds out that your justification is not reasonable at all, then the court has the absolute power to reject your complaint, and then you will not be having any criminal remedy. So always remember, whenever you have to file a complaint, make sure that you file a complaint within a period of limitation so that court will not raise any kind of objection in taking the cognizance. I have made this video because today in the courtroom I was observing a court proceeding, and in that particular case the complainant had already registered the complaint, but the case was filed after a period of 3 years. So the court was asking the question to the complainant that why did you delay in filing the case, why didn't you approach the court within the period of 3 years. So the counsel had no answer, the complainant had no answer. They were keep on insisting the judge that we had filed the complaint before the police station, but because of some reasons, because of some personal reasons, the police were involved, and we had a kind of fear of going to the police and approaching the court. We couldn't approach the court on time, but that was not the justified reason. So court could not take that justification in consideration and rejected the plea of the complainant, and also rejected the complaint filed by the complainant. So make sure whenever you file a complaint, that should be within the prescribed period of limitation.